Thank you very much, everybody, for joining this 3PB Brunch seminar. It's going to be given by myself, Mark Calway, and my colleague, Rachel Bloxwich, who you also see waving from her what looks like stately home there with the wooded background. Just a couple of short words of introduction. As I say, my name is Mark Calway. I'm 1989 called. I cover all aspects of family law, care proceedings, mainly, and also a significant amount of financial remedies proceedings. I also sit as a recorder dealing with family law and COP matters on the Western Circuit. Rachel qualified initially as a solicitor back in 2007, has practiced exclusively in family law since. Focus on financial remedies in her practice, but also private law children. She transferred to the bar in March of 2021. The two topics this morning, topic that I'm going to be dealing with first, which is conduct in financial remedies proceedings. Rachel thereafter is going to deal with the Bank of Mum and Dad and the impact of loans. In terms of the format, I'm going to go first, Rachel will go second. Our talks will be approximately between 20 and 25 minutes to allow for some time for questions at the end. If you have any questions during the course of the talks, and we're going to deal with questions at the end, both of us at the end together rather than me at the end of my talk and Rachel just at the end of her talk. If you could put those questions into the Q&A box, which you'll find at the bottom of your screen, rather than in the chat box, please. Just to remind everybody, of course, that the PowerPoint slides that you'll be seeing in a moment will be available to you by email after our talk has finished. As I've said, I'm dealing with conduct in financial remedies proceedings. In summary, I'm going to deal with the basics when conduct allegations are raised. Secondly, the four categories, those were set out by Mr. Justice Mostyn. Most recently, in the case of OG and AG, you see the reference there. As I'll come on to explain, conduct that will be taken into account by the court falls into four broad categories. I want to go on to deal with thinking briefly about issues of contact in financial remedies proceedings. Now we're in the new landscape of no fault divorce, whether that may or may not have any impact, perhaps things to look out for. And then the issue of conduct and needs. Is conduct something which is only really going to be relevant in sharing cases, or does it apply to needs, as we know, often said and told that needs trump virtually all other arguments? So just a quick consideration of those matters. So the basics. Section 25(2)(g, the Matrimonial Causes Act, of course, 22(2) setting out the criteria upon which the court will conduct the determination. Conduct which, in the opinion of the court, it would be inequitable to disregard. Now, there's no further definition provided by statute. So what has built up over the years since, and indeed before, is a body of case law which deals with those issues. And as I've already said, the starting point now has really got to be the Mostyn decision, the OG decision, but I'll come on to that in a bit more detail in a moment. The OG and AG categories, as I've said, that was a judgment of Mr. Justice Mostyn. Central quote from him: "Times have changed. The Financial Remedy Court is no longer a court of morals. Conduct should be taken into account not only where it is inequitable to disregard, but only where its impact is financially measurable. It's unprincipled for the court to stick a finger in the air and arbitrarily fine a party for what it regards as immoral conduct." It's clear that the concept is not one where the court would approach it to say, I'm penalising a guilty, for want of a better word, party by some form of damages or penalty for their guilt. Has the conduct, and this is what we really need to look at carefully in each and every case, is their conduct, the effect of which cannot be disregarded because it would be inequitable to do so, and where the impact can be measured in terms of the finance. So the four categories identified by Mr. Justice Mostyn in that case: gross and obvious personal misconduct, financial conduct which amounts to wanton and reckless dissipation of the assets, overspending and the like, litigation misconduct. Come on to speak about that in a few moments, but unfortunately something we're perhaps all aware of in our practices, where people unreasonably prevent disclosure, or at the top end, I suppose, set out to deceive, but numerous examples which I'm sure we can all think of. And lastly, the failure to provide full and frank disclosure. Possibly, of course, on what I've just said, you'll understand some connection between those last two. So going on to then deal with those, factors individually, or those categories, should I say, individually. But what I will say now, before I start, of course, as I've indicated before, there may be, of course, a connection, a number of these categories which all feed in to each other. But I think it's clearly helpful to consider what one's being told by a client by looking at these four basic categories. Does it fit into one or other of them? So gross and obvious personal misconduct. Now, there are a huge number of cases on this, stretching back to the early 1970s. What I would say is that the older cases, I'll touch on some of them, 70s and 80s, perhaps need to be treated with some caution because of what Mr. Justice Mostyn said in the OG case about the court not being a court of morals. That first bullet point, that conduct that has the gasp factor, well, that comes from the case of, sorry, I'm just getting my reference up now. That comes from the case of FS and JS. That's 2006 EWHC 2793. And what the judge said in that case, which was a case which involved assaults by the husband on the wife, that the conduct in question should have the gasp factor rather than inducing a mere gulp. I'm not sure that takes us very much further, but clearly intended to show that the personal misconduct had to be of a very significant degree. You see the examples I've chosen specifically for this slide, perhaps some of the most serious one can imagine, attempted murder. A more recent case, a 2019 case, that Purvis case is interesting because it's a decision by Mr. Justice Mostyn himself. That was a case where the husband was in prison serving sentences for serious sexual assaults and also for child pornography offences. It was clear that that was conduct which Mr. Justice Mostyn would be taking into account. Deception cases, the reference I've got there, and that case is somewhat aged, shall I say, now, but was a case where the husband, in inverted commas, had lived with the wife unbeknownst to her as a transsexual over many years, and had practiced that deception upon the wife. There are going to be lots of situations, one can't define them, but I think you know them when you see them, where there is something so significant that it's going to have to be taken into account by the court. What I say there, of course, it is very difficult to quantify often when advising, but what you do have to bear in mind is your consideration of that conduct. Certainly in this category, one needs to, again, link it to how it's financially affected the client. So, for example, in the attempted murder case, the H&H case, that had led to the wife, perhaps understandably, taking a long time off of work, not being able to earn what she'd previously been earning. So there was a pretty obvious link with the finances of the couple. But it has to be said, even in that case, the court indicated it wasn't going to go so far as to leave the husband, perhaps shockingly, with little or nothing. So one has to be careful. Financial conduct which amounts to wanton and reckless dissipation of the assets. Said very clearly by Mr. Justice Mostyn, it's only where this is clear and obvious. The M&M case and the Theory case, those were obvious examples of that conduct. M&M, the husband, an obsessive approach to litigation, including a hopeless application in the Chancery division, in that case, came under that category. The Theory case, that was one where the husband had frittered away, I think from memory, something in the region of 16 or 17 million euros in that case from the wife's accumulated assets on failed business ventures. It is, or experience tells us, that it is something which is rare. The high point, and probably the case that one really needs to look at if you think this is the issue you're dealing with, is MAP and MFP, which is 2015. That was a case where the wife was running dissipation, wanton and reckless dissipation of the assets by the husband, who was a very successful business person, but also had spent huge sums on drugs and prostitutes. The court saying, whilst that's reprehensible, one has to take people as one finds them. And part of the husband's character, leading to him being obsessive in terms of business and creating the success he did, perhaps also explained some of his less attractive traits. So that's really the high point, and one knows the hurdle one needs to cross. If you're able to show that that the dissipation was wanton and reckless, the remedy is for the court to add that sum or those sums which have been dissipated back into the calculation, the computation for later distribution. Okay, the third of the fourth categories, litigation misconduct. As Mr. Justice Mostyn makes clear again, this is something which is dealt with in costs, and he says severely penalised in costs, a direct quote from that judgment. It's very unlikely to affect the substantive award. The court wants to guard against a double penalty, having been penalised in costs and then affecting the award. There are circumstances where, in the most serious of cases, where that might be justified. But again, perhaps one's looking at a case where the conduct falls in one or more of these categories. For example, one looks back to the case of H&H on the wanton dissipation, the Chancery Division litigation, for example. So you see the mixing of the two. Bear in mind, and I know there's been a recent focus on this, practice duration 28A, and the reminders in recent case law about for all representatives and clients, that the failure to negotiate reasonably and with responsibility may lead to a cost sanction. So that's a form of litigation misconduct, of course, which will lead the courts to make costs orders when the information is available to make reasonable offers to compromise. Then that negotiation has to take place, in short. Lastly, failure to provide full and frank disclosure. Failure to comply with disclosure obligations may lead the court to use the evidential technique of drawing inferences as to the assets. And again, that's the expression used by Mr. Justice Mostyn. What he means there, of course, is adding back in notional amounts which the court take the view are there but have not been properly disclosed. I've given two relatively recent examples where the court will make findings against either of the spouses if they fail to disclose, I suppose, putting it colloquially, taking the view that there must be something to hide, and if there is, I'm going to take it into account. So again, emphasising, as the previous category did in terms of negotiating, the responsibilities on parties throughout the course of the proceedings to litigate reasonably, which includes, of course, the duty to disclose. Conduct and no fault. Of course, as we know, the Divorce Dissolution Separation Act 2020 introducing the concept of no fault divorce. We don't have to go through the rigmarole of those petitions with setting out behaviour. For those of you who weren't able to attend, can I point you to the previous brunch, which was provided by Hamish Dunlop and Poonam Bari on the Act itself. I think the slides are still available, which deal in detail with the Act. I say no more about it here than this. Will it, because people can't, my words, vent their spleen in their petition, will it lead to people wanting to make their conduct allegations in their financial remedies applications? Perhaps also, as a recent development, not in relation to the Act, but in terms of family relationships generally, a greater understanding of patterns of abuse and coercive behaviour, re-H&N, for example, coercive control. Are those going to be issues that one needs to look at in terms of conduct in financial remedies proceedings? What I would say is, go back to the basics. If you do have a case where that's what the client is telling you has happened, what are the financial implications of that behaviour? Has that led to one of the spouses who's been subject to that abusive behaviour losing their job, not having the income capacity they had previously? Always link it to the finances. I'm aware that there are certainly experienced commentators, not least Joe Edwards, previous chair of Resolution, who takes the view that no fault divorce is not in fact likely to lead to more conduct allegations in financial remedies proceedings. I'm not sure about that, and I think it's perhaps something we do need to guard against, and perhaps give strong advice to those who do want to run it. But the conduct is such, having looked at it carefully, it isn't going to be something which is going to affect the court's consideration. Conduct and needs, where I'm coming up to the end of my time, so just 90 seconds on this. It's often said that needs trumps everything. Conduct arguments aren't only for sharing cases. They may indeed impact on needs cases. Two recent examples there, I mention them only briefly. The first, the R versus B in Capita Trustees. Judgment making it clear that the court is entitled to prioritise the party who's not been guilty of conduct which is being taken into account, even in needs cases, which of course leads to the needs of the other party not being met by the award. And the last case there, making it clear that, perhaps this is more relevant to litigation misconduct issues and failure to negotiate, the court would not give a licence to litigate entirely unreasonably. So even in a needs case, if the litigation hasn't been conducted, has been conducted entirely unreasonably, then I'm afraid needs are not going to be met. Thank you very much for that. As I said, I'll be dealing with questions at the end. I'm going to stop sharing my screen now. I think I've managed to do that. And I'm going to hand over at this stage to Rachel. Thank you very much indeed, everybody.
Thank you, Mark. That was great. And I'm sure everybody's going to be scribbling away furiously and awaiting the notes. If you do have any questions, please feel free to pop them in the Q&A box. And Mark will deal with those at the end of my talk. Contrary to what Mark said, I'm not sitting in Downton Abbey. These are IKEA's finest bookcases. And I'm going to talk to you this morning about the Bank of Mum and Dad. I should just say, as a born and bred Brummie, I will probably call it the Bank of Mom and Dad, for which I apologise. I'm going to share my screen now and hope that works. That's perfect. Hopefully that will come up as a slideshow very shortly. But just while the technology is just being sorted out, I can absolutely start by telling you what I'm going to talk to you about this morning, which is the Bank of Mum and Dad. Is it a popular lender? We're going to then move on to the recent case of P&Q and deal with some of the authorities that addresses in that case. And we're then going to move on to practical considerations that we need to think about when we are looking at intervener claims and the Bank of Mum and Dad. I'm very grateful to whoever has just popped in the chat box some technical advice. I think that's very much in the spirit of what we've all been doing for the last 2 years, which is helping each other through with technology. So I am grateful for that. I am going to make a start. You will, of course, receive the slides after the presentation in any event. So the first thing I'm going to talk to you about is whether the Bank of Mum and Dad is a popular lender. In fact, it's such a popular lender that there is an acronym for it, which is BOMAD. You'll be pleased to know that I am not going to refer to it by that acronym, but I am going to tell you about the research that Legal and General have done in 2020. And when they did that research in 2020, 23% of housing transactions during that year involved funds from parents, and 56% of purchasers under the age of 35 will be receiving help from the Bank of Mum and Dad. And of that 56%, only 30% expect to pay, and I quote, some of the money back. And when you do receive the slides, there will be a link to that research, which is really interesting. The Legal and General research goes on to suggest that the majority of the funds that come from the Bank of Mum and Dad derive from their savings. But there are growing instances of parents or family members borrowing themselves on behalf of sons or daughters, nieces, nephews, grandchildren, etc., drawing down from pensions, investments, downsizing their own properties. So it isn't as simple these days as parents simply withdrawing funds from savings. The difficulty with that is if it's not just simply withdrawing funds from an ISA, for example, that can leave the Bank of Mum and Dad in their own financial difficulty, particularly if it's a case of them requiring funds to meet their own future care needs, to top up any state provision for care, or if they don't qualify for state provision for future care, funding it in its entirety. So the Bank of Mum and Dad sometimes isn't straightforward. And as we also know, the Bank of Mum and Dad isn't straightforward when it comes to spouses separating. I'm sure we all have numerous cases that we can cite where one spouse has asserted that there are debts to a family member that need to be taken into account before we go about dividing assets. It regularly appears in a Form E, and it regularly is a matter of surprise to the person who receives that Form E, who says, well, actually, that was a loan, that was a gift, or they didn't know about it. And we often see appended to Form C letters from parents that have quite clearly been written at the time of the exchange of Form E, saying, oh, by the way, yes, I did loan something 15 years ago. So it's not uncommon. We've now got a very helpful case of P&Q. Again, if you, when you receive the slides, it will have the citation on it, but it's a 2022 case. and it was before His Honour Judge Hess. Just very briefly dealing with the facts of this case, the wife was 48, husband 45. They met as students, 2 children aged 10 and 11. They divided their time between, oh, thank you, Delphine, she's popped it in the chat box, that's really helpful. They divided their time between Germany and the UK. They had a house in England. They separated in 2019, and at that point the asset pot was circa £6 million, which comprised property, shares, and pension assets. This case does deal with some of the issues relating to the parties' shares, but for the purposes of today, the most important aspect of that case is the way in which the court dealt with various monies going to family members. So there were 4 transactions in all that the court was concerned with. Firstly, the husband transferred £25,000 to his sister. That sorted itself out prior to final hearing, and the wife didn't pursue a recovery of that amount. Transaction number 2 was a transfer from the husband to his father. The court actually accepted the husband's explanation as to what had happened on that occasion. So we're now dealing with transaction 3 and 4, which were the key transactions. So this one was husband who had paid £150,000 back to his mother in June 2020. He says that his mother transferred £150,000 to each of her 3 children in 2010. No documents drawn up, no evidence that this was to do with any form of tax planning, no demand for repayment ever made, and when the husband paid this money back to his mother, he didn't make wife aware of that, and it became apparent following an exchange of Forms E. The second, well, the 4th transaction, I suppose, the second one that the court was particularly concerned with was a loan that the wife asserted was from her father for €30,000 to study for an MBA. With regards to this loan, a contemporaneous document existed, described the payment as an interest-free loan, no date for repayment, and went on to say as long as the father didn't demand repayment, it could be repaid at the wife's own discretion. That loan was not mentioned in the wife's Form E, not mentioned in her narrative statement, and it stated it had come to light. The wife stated it had come to light when she was going through some historical documents and chatting to her father, unsurprisingly, just before the final hearing. In terms of the loan from the mother to the husband, the £150,000, the court heard some evidence from the husband's mother. She said, I would never pursue any of my children by way of litigation, and if it's not repaid, I will simply rearrange the terms of my will to reflect that. One of husband's sisters had paid back some money, but around 30 to 40,000, so nowhere near what had been given. So when the matter came before His Honour Judge Hess, he very helpfully drew together a number of authorities on this issue. So the first step in this process would be, should these monies be regarded in strict legal terms as gifts or loans? So in terms of the first step, we have to look at, is there an intention to give? So can we prove that there was an intention by the person who advanced these funds to actually give them? And in this case, His Honour Judge Hess said that neither party had been able to show this. So these were potentially transactions that could be considered as loans, and therefore technically they could be enforced. So they passed the first part of the analysis, which is, was there an intention to give? And the answer is no. So a loan was established, and then the court must consider whether that is a hard loan and should therefore absolutely appear on the computation table, or a soft loan, which the judge may decide as an exercise of discretion to leave out. The key parts of that sentence are the word may and discretion. Just because the court has said it's a soft loan doesn't mean they absolutely automatically will leave it out. It means that the court may decide to do so as part of its exercise of discretion, or indeed may choose to treat that soft loan in a different way when looking at the computation of assets. His Honour Judge Hess said in P&Q that this is not, this is an elusive topic and difficult to pin down. It's certainly not an exact science. In P&Q, His Honour Judge Hess refers to a very helpful article by Alexander Chandler of 1KBW in the 2015 edition of the Family Law Journal. It is, although it's obviously predates P&Q, a very, very helpful article. And not only will you receive the slides, which very sadly you can't see at the moment, but you will receive the slides, but you'll also receive a link to the to P&Q, which refers to that article. In P&Q, the case of M&B is looked at. That's a 1998 case, and W&W, which is a 2013 case. In M&B, it was pointed out the fact that an appeal had been allowed on one of the grounds for appeal was the trial judge's failure to distinguish between hard debts, such as a debt to a bank, and soft debts, such as monies advanced by the mother and brother. We have to be really careful, however, when we're looking at that, because monies advanced from a mother or brother doesn't necessarily mean that it would be a soft debt. So, for example, a mother or brother could loan money and a charge be put on the property. That would not be considered potentially as a soft debt. In W&W, Mr. Justice Ryder provided us with quite a helpful sentence when looking at soft debt, saying provided the wife doesn't fall out with any of the principals, then they will wait for their money to be returned. And I think that's probably encapsulates soft debt in a sentence, really. But in P&Q, His Honour Judge Hess went on at paragraph 19 to look at some criteria that might point the court towards a hard loan and some criteria that might point the court towards a soft loan. So when we're looking at hard loans, one of the things the court looked at was, does this involve a finance company? If it doesn't, does it have a commercial feel? Now, obviously, it's difficult in a sense to define what a commercial feel is or isn't, but we all know, though, for example, if we purchased a car, the car loan company aren't likely to say, well, you can pay it back as and when you want to. So it's that type of arrangement with terms for repayment. Another factor is there a written agreement? And that's a contemporaneous written agreement, not something that somebody has decided to draft when Forms E have been exchanged. And also that contemporaneous agreement is very much dependent on what it says, whether it's what I would call a kitchen table agreement, where everybody sat down and talked to each other and scribbled it on the back of a piece of paper, or is it perhaps something a little bit more formal? If there is default in payment, has there been written demand for payment? Has there been no delay in enforcing the obligation, i.e. the repayment hasn't been asked for simply because of these proceedings? Is there a threat of or actual litigation or intervention? And also the court will consider the amount involved. So is it such that a creditor would be unlikely to waive the obligation either wholly or partly? So in terms of it being, say, £150,000, that's highly unlikely to be waived by a creditor, whereas £2,000, £3,000, £5,000, maybe even £10,000 could potentially be waived by a creditor wholly or partly, dependent on the circumstances. And then looking at what, balancing that against, is this a soft loan? So if it doesn't meet the criteria of a hard loan, what are the things we look at for soft loans? Is it from a friend or family member who is unlikely to want them to suffer hardship? Are they on good terms with each other? Did this advance of money arise informally? Is there no written agreement? Again, contemporaneous written agreement, or is it a very informal written agreement, an IOU on the back of an envelope? If it doesn't have a commercial feel to it, if there has been no demand for payment or a very delayed demand for payment, and again, looking at the amount involved, I would just say in terms of the amount involved, we would have to consider this in the context of where the money has come from, who it's come from, the assets involved in the case. So large amounts could potentially be considered soft loans dependent on the circumstances, although the larger the amount, potentially the more unlikely that is. What happened in P and Q was, unsurprisingly, based on the facts of the case, wife's debt to her father was considered at the softest end of the scale of loans. Very unlikely that the wife would be required to make repayment, despite the fact this contemporaneous document existed. It was very telling that essentially the wife had forgotten about this, as had the father, and it only arose in the context of discussions around these proceedings. And then dealing with the husband's debt to his mother, the mother's evidence was very important to the court. It was very clear that she didn't intend to enter into litigation with any of her children, and that she was content to view it essentially as an advance on her inheritance. The court concluded that the husband had essentially paid it back to his mother at the point that he did, because he was concerned about his wife's claim against that sum, and that had the proceedings not been in train, it's highly unlikely that that repayment would have been made. The court's decision meant that the wife's debt was not included in the asset schedule, and they essentially did an add back, if you like, onto the husband's side of the schedule in terms of the £150,000. That was perhaps a little bit easier in this case, given the assets involved and the fact that there was clearly more than enough to meet need. Just turning briefly to practical considerations. So I would imagine that everybody has either acted for a husband or wife who raises the spectre of family loans, or potentially given advice to a family member who says that they have loaned money and they want that to be taken into account in the context of their son or daughter's divorce proceedings. We need to consider whether, in the circumstances, it's appropriate for the people who have advanced monies to be interveners in this case. I don't think it is on every occasion. I'm sure that everybody has seen position statements which refer to the case of TL and ML, which is a 2005 case, which is a Mr. Justice Mostyn case. Oh, Delphine's very helpfully put that in the reference in the chat box, but again, that will be in the notes that come across to you. Mr. Justice Mostyn said, in my opinion, in every instance where a dispute arises about the ownership of property in ancillary relief proceedings between a spouse and a third party, these are the things we should do, which is join the third party at the earliest opportunity, directions to be given for fully pleaded points of claim and points of defence, separate witness statements, and for this matter to be heard as a preliminary issue prior to the FDR hearing. I would urge you to approach that case with a little bit of caution on the basis that that relates to a third-party beneficial interest. We need to differentiate between indebtedness, monies owed by way of debts, versus beneficial ownership. And we all know the authorities in relation to trying to establish beneficial ownership of a property by virtue of contributions. So TL and ML is helpful, but is not always the most appropriate way forward. There is nothing to prevent the court considering whether that it's capable of this issue being dealt with by way of witness evidence, rather than joining these creditors as as interveners. We all know intervener claims are costly, time consuming, and obviously the costs rules in terms of the presumption that each party pays their own costs don't apply to intervener claims. So we really do need to tread carefully and pragmatically with intervener claims in that sense. So if you are acting for the intervener, or indeed for husband or wife where intervention is a possibility, I think the first step would be consider the overriding objective. We need to consider whether these issues are capable of being dealt with in another way. Are these issues, do they need to be determined at an early stage to ensure efficiency, lack of delay, or is there a potential for, in fact, creating an inefficient process with a lot of delay? If you're acting for the potential intervener, you've got to be incredibly careful to separate your position from that of the son or daughter. I just refer you to a comment made by His Honour Judge Hess in P&Q when he said, "It seems most unlikely that these proceedings apart, the debt would ever have surfaced." And I think that is the question that you must ask yourself if you are being asked to advise about intervener claims. If the court determines that it's appropriate to hear the matter via witness evidence, the court can, of course, assess at final hearing the alleged debt as part of the Section 25 criteria, namely Section 25(2)(b), which is, of course, the financial obligations and responsibilities which each of the parties to the marriage has or is likely to have in the foreseeable future. In terms of treating this as a witness matter rather than joining interveners as parties, obviously that does create some practical considerations, because the issue of whether this is a debt, and if so, is it a hard loan, a soft loan, that will be a live issue at the FDR because it won't have been determined. What I would say about that is there are lots and lots of live issues usually at FDR where the parties factually dispute things like earning capacity, housing need, and there are cases where that can be navigated around, especially given a pragmatic approach in terms of the assets versus the likely costs of proceeding. If the court decides they are going to treat these loans as something that they can hear witness evidence on, the court doesn't have any power to make an order in the creditor's favour. They're not a party to proceedings. That can be worked around again. So, for example, the court could award a lump sum to one party, with them offering an undertaking to the court to repay the creditor. But if there are high amounts involved, complex legal issues, it may well be that you can't get around joining these people as interveners to that part of the dispute. There is a procedure to that. It's a Part 18 claim. It should be supported by evidence, and the court really should be getting away from the informal joinder of parties. There should really be an assessment at an early stage of what it is they've got to say and the evidence that they have to support that. I'm mindful of the time and apologise again for the technical issues. I think we're going to try and deal with some questions now, which I'm hopeful that people have put into the chat box. Mark's going to answer any questions that you might have on conduct, and then I will move on to deal with any questions about the Bank of Mum and Dad. Thank you very much.
Rachel, thank you very much for that, and congratulations for going through the technical problems and dealing with it so clearly. Incredibly helpful. Thank you so much. Thank you for questions that you put in the questions box. There are a number of them. I'm just able in a few minutes just to deal with a couple of issues that have been raised. Firstly, a question about procedure for raising these issues. Well, of course, conduct, if it took place during the course of the marriage or after the parties separated but before the litigation starts, so dissipation or personal misconduct, then of course that's in your Form E. And certainly at the initial stages, the first appointment, judge will want to look at whether that's something that you need to set out in a statement. Indeed, often these issues are perhaps dealt with in that sense as something of a preliminary issue. The evidential burden is on the person bringing those allegations, setting them out, and shown obviously on the balance of probabilities. As far as another question about whether if a deadline has been given to raise conduct issues and that deadline's been passed, but there are then litigation conduct issues, and of course those come during the proceedings or possibly before if there's been negotiation, there are disclosure problems, the other party hasn't complied with various directions, for example, it's not too late to raise those. Those of course wouldn't be in your Form E. They form a part of the proceedings which are dealt with, as I've said, by way of costs orders primarily, so would be dealt with at the end. So in terms of that sort of conduct, i.e. litigation conduct, never too late. Okay. Just one, because it gives an example, and I won't mention the particulars other than to say a case where there's an allegation that husbands spending money on the service of prostitutes, perhaps some £100 a week. The total assets are some £3 million. One would have thought that although it might be said that was personal misconduct, which was reprehensible and does have a financial impact because it's money being spent, proportionality, of course, is always important. So one needs to look at that. If the total fund is 3 million and it's spending of £100 a week, depending, I suppose, over how long that has been going on for, it may well be said the court doesn't need to go into those matters to deal with a case where the pot is that big. So do have as I've said, do have a thought to what precisely the financial implications of this conduct is. Thank you. Rachel, do you have any questions which you want to deal with by way of giving short answers now?
Yes, thank you, Mark. Just a couple. I'm mindful of the time. I think we've had a couple of questions about, is there a presumption? Is there either a presumption that an advance is a loan unless proved otherwise, or indeed a presumption that monies are a gift unless proved otherwise? There isn't a hard and fast rule, sorry everyone, as there is in so much financial remedy work. There is no hard and fast rule. I think every case turns on its individual circumstances, but I would be turning now to P&Q to go through that exercise. So firstly, if someone is alleging that it is a gift, is there an intention to give? How can we evidence that there is an intention to give? If we can't then get over, if we do then cross that hurdle and say, actually, there was no intention to give, we would then move on to, is it a hard loan or is it a soft loan, using that criteria about commercial feel Is there an agreement? An agreement isn't the be-all and end-all. Obviously, it's helpful. And what I would say is, if you work in firms alongside conveyancers, I would be talking to your conveyancers, because they obviously have to prove source of funds for property purchases. If part of the source of those funds comes from a parent, then it might well be an appropriate time to talk to that person about whether it's necessary for an agreement to be drawn up with regards to that. Another question is, if, for example, parents allege that it's a loan, it must be repaid, and have actually gone on to issue their own civil proceedings or pre-proceedings in terms of a letter of claim, how do we go about dealing with this? There is a case which I will send across to you, which sort of addresses that, because it's a matter of Goldstone and Goldstone. It's a 2011 case, and it was considered by Lord Justice, as he was then, Hughes, saying it's desirable to equip a single court with the means of deciding all relevant connected issues within the proceedings. So given that they are likely to impact on those proceedings, then it's, I would say, desirable to invite them, not necessarily at that stage to intervene, but at least to understand more about their claim. If it is that they intend really to pursue this through the civil courts, probably an intervention application would be preferable, rather than dealing with it in two separate courts, dealing with the same facts. So absolutely try and get the court to seize both issues. Although an intervention claim is costly, it will certainly be less costly, depending on the amount involved, than pursuing civil proceedings alongside family proceedings, and the court won't like that either, for obvious reasons. I think that probably gets us to the point where we have run out of time, and I do apologise once again for the technical issues that I have had this morning. You will receive the slides, you will receive Mark's slides, also the citation for P&Q, and also the other citations that we have referred to, so that you can read the judgments if you want to. It just remains for me to say thank you very much to everybody for attending this morning. We're really grateful to everybody who takes time out of their morning to join us, and we look forward to joining you, for you to join us at our next brunch, which we are taking a little break because of the forthcoming school summer holidays, and the next one will be on the 29th of September. And if you keep an eye on your email, then all of the relevant information will be sent out to you. I hope everyone has a lovely afternoon, and it has been great to see everybody. Take care, everyone.
Thank you. Cheerio.